Anybody else? All right. I don't know what's wrong with the system. I guess I'm glad we got through the trial before this happened. But in any event, we're here on cause number 24676, State of Mississippi versus Michael J. Brown, defendant's present with his co-counsel, Mr. Lockhart, the state president through the DA's office. We're here for a sentencing hearing. Jury having returned verdicts of guilty to each of the 2 counts of embezzlement contained in this indictment. It's been reported, accepted as verdict of the jury. Brown's been adjudicated guilty of embezzlement in each of these 2 counts. Prepared to go forward with sentencing now. Before we begin the sentencing hearing, I'll note that as Miles' view of the statute goes, that the minimum period of incarceration is 0 years, the maximum period of incarceration is 20 years, the minimum fine is $0, and the maximum fine is $5,000 for each count. I'll hear anything on behalf of the state relative to sentencing.
Your Honor, the court has heard the testimony, as has everybody else for the last few days. There's no need to go into what happened in this case. I would remind the court that this defendant is facing another indictment here in Rankin County, and it involves the same guardianship that he allegedly embezzled funds, so he does have that pending on him. I will tell the court that in Hinds County, he has been indicted. It's my understanding he has been served a multi-count indictment for embezzlement that he did over there, and that was in relation as well to the guardianship of Damon McClinton.
Issue of restitution, Mr. Buckley.
Your Honor, we can leave that matter open for 30 days. We have been in touch with the victim in this case, Damon McClinton. He's unable to be present today. There has been the Chancery Court in Hinds County has ordered Mr. Brown to pay back over $1.2 million. As far as I know, none of that has been paid yet. But I believe in this case, we've shown that $550,000 was taken from the guardianship funds of Damon McClinton and embezzled by Mike Brown. So we would ask at a minimum that $550,000 be ordered to be paid in restitution to the victim in this matter. We would also ask that any sentence that he gets run consecutive to any time that he's already been over here on whatever contempt charges that he's been here on, and that he not be given credit for time served on these charges because he had never made a bond or posted a bond that would allow him to be out. So we just ask that they run consecutive with each other, whatever the court decides is the appropriate sentence.
All right, I'll hear from the defense.
I think on restitution, Mr. Shackelford testified that he had made significant payments to in regards to the money he got. It was over $100,000, he had said in his testimony. I think to make the court aware that I did not receive any money from any of this indictment and charges. I have nothing, the court's known me for over 20 years, so there's nothing more I can say to the court in reference to character and that, and the court knows me well. So.
What about what have you been in jail? What's been holding you in jail? Are you in jail on contempt?
Yeah, contempt.
From Hinds County or Rankin County?
Rankin County.
Rankin County contempt?
Yeah.
Were you in jail on contempt in Rankin County when you got served with this charge?
Yes.
So you've never been out of contempt in Rankin County?
No, because he gave me no bond in that contempt.
Anything else?
None, Your Honor.
Or anything else from the state?
No, Your Honor.
I'm ready to propose something. Mr. Mr. Brown, this is obviously a very sad occasion. It's a difficult thing to see a member of the bar in this situation. Unfortunately for you, you really have nobody but yourself to blame for being here. From my knowledge of the law, knowledge of procedures, in Chancery Court, money should have been deposited to the guardianship account. If the money had been deposited to the guardianship account, you got the order prior to expending those funds that you were supposed to under the law. You would have had a record of all the expenditures would have been in the court file, and there would have been court approval for every penny that was spent out of that account. In fact, that part of the money that was received from the estates of this Mr. McClinton's mother went into a guardianship account, and the fact that $1 billion, $1 billion plus, 1.2 something million dollars specifically and intentionally did not go into that account was the first thing where you started to stray. It's also sad that Dr. Henry's estate, he was taken care of. He lived through a time that was very difficult. He made money for himself and his family. He tried to provide for that. He left that to his daughter, who unfortunately died shortly after her. And to see such a large portion of that squandered in the way that it's been squandered is just unacceptable. I've heard your explanation. Not only have you been found guilty of embezzlement here, but basically you accepted no responsibility for your actions through the process. You have taken on both the expert in this case, some allegations that I think that were inappropriate, challenged judges, both retired and sitting, in ways that I believe were inappropriate. But in any event, you are where you are today because of the actions that you took and the way that you handled the responsibilities that you had as attorney for this guardianship. With that in mind, I'm going to sentence you to a term of 20 years in custody of the Mississippi Department of Corrections on each of these 2 counts. I'll order that they run consecutively with each other. I'm going to suspend the last 10 years of the second case, count 2, and place you on 5-year supervised probation on the court standing order supervision. Specific conditions which be that you pay restitution in the amount of $1.2 million to Demond McClinton. And I'll order that you begin paying at a rate of not less than $300 a month, beginning on the last working day of the first full calendar month after your release from incarceration, and continuing from month to month thereafter until paid in full. You will get credit for any payments that are made either by Mr. Thomas McClinton or payments that are made by Lionel Shackelford relative to this $1.2 million. I'll also order that you pay court cost fees and assessments in the amount that will be determined by the clerk. That will be part of the monthly payments that you'll make. As indicated, these sentences will run consecutively to each other and will be consecutive to any time that you're serving on contempt charges that you're presently serving. Further, the court found you in contempt, direct criminal contempt, on 3 occasions during the course of this trial for the conduct that was noted in the record that I believe was calculated to embarrass or prevent the orderly administration of justice. And for each of those 3 counts, you'll have a separate sentence in each of 30 days in the Rankin County Jail. Those sentences will run consecutively to each other and will run consecutively to the time that I've imposed as a sentence in 24-676. That time will be served upon any release from the Mississippi Department of Corrections. Anything else, Mr. Brown?
The other thing I'd ask you is, you said on repayment by Demond, Thomas McClinton and Shackelford, are you also going to include Lottie Campbell?
Well, I'm not sure that Bobby Campbell is a player here. I'm not going to include her. The people that I know that you were involved in with this money based upon the testimony here was Thomas McClinton and Lon Shackelford. Shackelford's obviously made some arrangements to make some payments toward that. And so any payments that are made by either of those two men toward that $1.2 million, you'll receive credit for that. Anything else?
No.
All right. Anything else from the state?
No, Your Honor.
All right, I'll prepare the order on this. Good luck to you, Mr. Brown.